I was staring at the 20-foot icicle hanging from my cabin's roof when the white sedan pulled up my driveway. And somehow I knew this peaceful morning in the Colorado Rockies was about to become significantly less peaceful. My name is Lucas Kensington, and I'd bought this cabin in Evergreen, Colorado, about 6 months ago. The place was a dream 800 square feet of rustic charm nestled among pine trees at the end of a private gravel road. I worked remotely as a software developer, and this was supposed to be my escape from the chaos of suburban Denver. The cabin sat on 2 acres of land that I'd purchased outright, and I'd specifically chosen a property far enough from the main HOA neighborhood to avoid their jurisdiction. Or so I thought. The sedan door opened, and out stepped a woman who looked like she'd been dressed by a committee dedicated to the aesthetic of, "I need to speak to your manager." Her name was Patricia Hendricks, and I'd met her exactly once during the closing process. She was the president of the Mountain Vista HOA, a position she wore like a military rank. Her blonde hair was cut in that distinctive angular bob that seemed to be issued along with the HOA Presidency Handbook. She was probably in her early 50s, with sharp features that seemed perpetually pinched in disapproval. "Mr. Kensington," she called out, her voice carrying that particular tone of forced politeness that made my teeth itch. "We need to discuss your property." I set down the coffee mug I'd been holding and walked toward her, my boots crunching in the February snow. "Miss Hendricks, what brings you all the way up here?" She gestured dramatically at my roof. "Those icicles are a safety hazard and a violation of our community standards." I followed her pointed finger to the impressive collection of ice formations hanging from my eaves. The longest one was indeed massive, probably weighing 100 pounds or more. It sparkled in the morning sun like nature's own chandelier. "They're on my property," I said slowly, trying to understand her concern. "And there's nobody around for them to fall on. The nearest structure is your community, which is a quarter-mile down the mountain." "That's not the point." Patricia pulled out a folder from her car. Of course, she had a folder, and flipped it open. "According to the Mountain Vista HOA covenants, all properties within viewing distance of the main community must maintain aesthetic standards that reflect well on our neighborhood values." "I'm not part of your HOA," I said, my patience already wearing thin. "I checked before I bought. My property deed specifically states I'm outside your jurisdiction." Her smile was the kind you'd see on a cat that had just cornered a mouse. "Actually, if you read the amended bylaws from 2018, any property within a 1-mile radius that can be viewed from our community common areas falls under our aesthetic guidelines." "That's insane. Nobody mentioned that when I bought this place." "Ignorance isn't an excuse, Mr. Kensington. The bylaws are public record. I'm here to inform you that you have 48 hours to remove those icicles, or you'll be fined $500 per day until compliance is achieved." I felt my jaw tighten. "You can't fine me. I'm not a member of your HOA." "I don't pay dues and I didn't sign any agreements." Patricia's expression hardened. "The previous owner was aware of the amended bylaws. When you purchased the property, those obligations transferred to you. It's all in the county records. Then show me the documentation." She pulled out a sheet of paper with what looked like a scanned document. The quality was poor, and I could barely read the text, but there was something about extended jurisdiction and visual impact zones. It looked official, but something about it didn't sit right with me. "I'll need to have my lawyer look at this," I said. "That's your right," Patricia replied, her voice dripping with false sweetness. "But the 48-hour countdown starts now. It's currently 9:15 on Tuesday morning, so you have until 9:15 on Thursday morning. Have a good day, Mr. Kensington." She climbed back into her sedan and executed a perfect three-point turn, leaving me standing in the snow with a growing sense of dread. I looked back at my cabin, at the icicles that had formed naturally over weeks of freeze-thaw cycles, and wondered how something so simple had become a legal issue. Back inside, I immediately called my real estate attorney, Mark Davidson. He'd handled the cabin purchase and had been thorough about checking for any HOA entanglements. His secretary said he was in court but would call me back within the hour. While I waited, I did my own research. The Mountain Vista HOA website was a masterpiece of passive-aggressive community management. Their bylaws section was extensive, running to nearly 200 pages of single-spaced regulations covering everything from acceptable fence heights to the precise shade of brown that exterior paint could be. I searched for anything about extended jurisdiction or visual impact zones. After an hour of raiding, my eyes burning from screen strain, I found it. Buried in an amendment from 2018, there was indeed language about properties within a reasonable viewing distance being subject to certain aesthetic guidelines. The language was vague enough to be concerning but specific enough to potentially have legal teeth. However, it also stated that affected property owners would be notified in writing within 30 days of the amendment's passage and would have the option to formally contest the inclusion of their property. I'd bought my cabin in August of the previous year. The amendment was from 6 years ago. If the previous owner had been notified and hadn't contested, did that obligation really transfer to me? Mark called back at 10:30. "Lucas, what's going on?" I explained the situation, reading him the relevant passages from the HOA bylaws. He listened without interrupting, which I'd learned meant he was taking the problem seriously. "Okay," he said finally. "First, don't remove those icicles. Second, don't acknowledge in writing that you're subject to their authority. Third, let me pull the complete chain of title and all recorded documents. If this amendment was properly recorded and the previous owner was notified, it might have created what's called an equitable servitude that runs with the land. In English, it means even though you're not formally part of the HOA, if certain conditions are met, you might still be bound by some of their rules. But in this is important, the burden of proof is on them to show that proper notice was given, proper procedures were followed, and that their rules are reasonable and not arbitrarily enforced. What do I do about the 48-hour deadline? Ignore it. They'll have to take you to court to enforce any fines, and that gives us time to challenge the underlying authority. I'll start pulling documents today. After hanging up with Mark, I tried to focus on work, but concentration was impossible. Around 1 in the afternoon, I decided to take a break and drive down the mountain to the Jefferson County Administration Building. If the HOA's claims were in the public record, I wanted to see them for myself. The clerk at the recorder's office was helpful, a young guy named Brandon who seemed to genuinely enjoy hunting through property records. He pulled up my deed and started tracing back through the history. "Here's your purchase last August," he said, pointing at the screen. "Let me see what we've got for recorded easements or covenants." He clicked through several screens, his brow furrowing. "Okay, this is interesting. There's a document recorded in 2018 by the Mountain Vista HOA claiming expanded jurisdiction, but it's not actually tied to your specific parcel number. It's more like a general declaration." "What does that mean?" "Well, normally when you have a covenant or restriction that affects a property, it gets recorded against that specific property's legal description. This is just kind of floating out there saying we claim authority over properties in this general area. I'm not sure it has any actual legal effect." "Can you print all of this for me?" Brandon spent the next 20 minutes compiling a packet of every relevant document. When I left the administration building, I had a 3-inch thick stack of papers and a growing sense that Patricia Hendricks might be overreaching her authority. Wednesday morning started with an email from Patricia. The subject line was "First Notice of Non-Compliance," and the body was a formal letter threatening the $500 daily fine starting Friday morning. There was also a new claim that the icicles constituted a fire hazard because they could damage the roof and potentially cause structural issues that might lead to electrical problems. The fire hazard angle was new and seemed like a reach, but it gave me an idea. I looked up the number for the Evergreen Fire Protection District and called their non-emergency line. "Fire District, this is Amy speaking. Hi, my name is Lucas Kensington. I have a question about icicles on my property. Someone's claiming they're a fire hazard, and I wanted to verify whether that's actually a concern from a fire safety perspective." "Icicles?" Amy sounded puzzled. "Can you hold for a moment? Let me transfer you to one of our marshals." A minute later, a gruff voice came on the line. "This is Fire Marshal Thompson. You've got questions about icicles." I explained the situation, including Patricia's claim about fire hazards. There was a long pause. "Son, I've been doing this job for 23 years, and I've never once classified icicles as a fire hazard. They're frozen water. Water puts out fires. Now, heavy ice buildup can cause structural issues, and structural failure can lead to all kinds of problems, but that's a building code issue, not a fire safety issue. Where's this property?" I gave him my address. "And you say someone from an HOA is claiming I'd consider this a fire hazard." That's what her email says. Well, that's news to me, and I'm the only fire marshal in this district. Tell you what, I'm going to swing by this afternoon and take a look. If someone's using my office's authority to push HOA nonsense, I want to know about it. Marshal Thompson showed up at 2:30 in a red pickup truck with the fire district logo on the door. He was in his late 50s, built like a retired linebacker, with a weather-beaten face that suggested he'd spent more time outdoors than in an office. "Lucas Kensington?" he asked, shaking my hand with a grip that made me wince. "That's me. Thanks for coming out." He walked around my cabin, examining the icicles from various angles. Then he asked to see the interior, checking the roof structure from inside the loft. "Your cabin's solid," he said finally. "Those icicles are impressive, I'll give you that. In a perfect world, yeah, you'd knock them down before they get too heavy. But a fire hazard? Absolutely not. And honestly, since this is your private property and there's nobody around for them to fall on, it's not really anyone's business but yours. The HOA president says I have to remove them." "Are you part of that HOA?" "No, and I made sure of that before I bought." Marshal Thompson's expression darkened. "Then she's got no authority over your property, and she definitely doesn't get to invoke fire safety regulations that don't exist. You got that email handy?" I showed him Patricia's email on my phone. He read it carefully, his jaw tightening. "This is a problem," he said. "She's making claims about fire safety that aren't true, and she's implying that these claims come from my office. That's misrepresenting a government official, which is a serious issue. Do me a favor and forward that email to me. My card's got my email address." He handed me a business card, and I forwarded the email immediately. "What happens now?" I asked. "Well, first I'm going to document that I inspected your property and found no fire safety violations. Second, I'm going to have a conversation with Miss Hendricks about proper use of fire safety regulations. And third, I'm going to make sure she understands that she can't throw around my office's authority to enforce HOA rules. After Marshal Thompson left, I felt a surge of relief. At least I had an official on my side. That evening, Mark Davidson called with an update on his research. "I've gone through everything," he said. "The short version is that the HOA's 2018 amendment is legally questionable at best. They recorded a declaration claiming expanded jurisdiction, but they never followed the required notification procedures. Colorado law requires that affected property owners receive certified mail notification with an opportunity to contest. There's no record of that happening. So they can't enforce anything against me. Not so fast. The law's a bit murky here. They could argue that the previous owner's knowledge constituted sufficient notice and that you assumed those obligations when you bought. We'd win that argument, I think, but it would take going to court. How much would that cost me? Probably $5,000 to $10,000 in legal fees, assuming it doesn't drag out. But here's the thing, they'd have to sue you first to enforce their fines. And if they do that, we can counterclaim for harassment and abuse of process. The question is whether they're willing to take it that far over some icicles. Thursday morning, 9:15 came and went. I didn't remove the icicles. I sat at my desk, working on a software update, waiting for something to happen. By noon, nothing had. I was starting to think Patricia might have backed off after her conversation with the fire marshal. I was wrong. At 2 in the afternoon, I heard vehicles coming up my driveway. Plural. I looked out the window and saw 3 cars: Patricia's white sedan, a black SUV, and a silver minivan. 7 people got out, including Patricia and several others I didn't recognize. I went outside to meet them. "Can I help you?" Patricia stood at the front of her group like a general leading troops into battle. "Mr. Kensington, your compliance deadline has passed. We're here to document the violations and begin the formal fine process. This is our HOA board and our attorney, Deborah Marsh." A woman in her 40s wearing an expensive-looking business suit stepped forward. "Mr. Kensington, I'm representing the Mountain Vista HOA. My client has authorized me to inform you that as of 9:15 this morning, you began accruing fines at $500 per day. Additionally, we're documenting all violations for potential legal action." "Get off my property," I said evenly. Deborah's eyebrows rose. "Excuse me." "You heard me. This is private property. I'm not part of your HOA and you have no authority here. Leave now or I'm calling the sheriff." "We have every right to document violations visible from common areas," Patricia said shrilly. "We don't need your permission to look at your property from the road. You're not on the road. You're on my driveway, which is private property. Last chance, leave voluntarily or I'm making a trespassing complaint." The group huddled together, whispering. Finally, Deborah spoke. "We'll return to the property line. But the fines stand, Mr. Kensington. You'll be receiving formal notification via certified mail." They retreated to their vehicles but didn't leave. Instead, they parked at the end of my driveway, right where it met the county road, and started taking photographs and videos of my cabin. I went back inside and called the Jefferson County Sheriff's Office. The deputy who answered took down my information. So they're on the public road, right at the property line. But they were on my driveway when I told them to leave. Unfortunately, if they are on the public road, they can photograph whatever they want. If they come back onto your property without permission, call us immediately and we'll send a unit. But taking pictures from the road isn't illegal. I understood, but it didn't make the situation less infuriating. For the next hour, Patricia's group remained at the end of my driveway, documenting every angle of my cabin. Finally, they left, and I received an email 20 minutes later with a formal notice of violation and accumulated fines. According to their calculations, I now owed $1,500 for each of the 2 days since the deadline. The email included a payment portal link and a warning that failure to pay within 30 days would result in a lien being filed against my property. I forwarded everything to Mark, who called me back within minutes. "They're really doing this," he said, sounding almost impressed. "Okay, here's what we do. Don't pay anything. Don't acknowledge the fines in writing. I'm going to prepare a cease and desist letter explaining that you're not subject to their authority and that any attempt to file a lien will be challenged. I'm also going to include the fire marshal's findings." Will that work? It might. Or it might just escalate things. With HOAs, it's hard to predict. Some back down when faced with actual legal pushback. Others double down out of pride. Friday morning, I woke to find a surprise. Someone had posted about my situation on a local Facebook group called Evergreen Community Watch. The post wasn't from me. I didn't even belong to that group. But it had a photo of my cabin, complete with icicles, and a rant about how inconsiderate property owners were refusing to maintain basic safety standards. The post had been shared 43 times and had over 100 comments. Most were supportive of the HOA's position, calling me irresponsible and selfish. A few people questioned whether the HOA had authority over non-member properties, but they were shouted down by others claiming that community standards superseded individual property rights. I felt my blood pressure rising as I read comment after comment from people who didn't know me, passing judgment based on Patricia's framing of the situation. Someone had even called for the county to condemn my cabin as unsafe. Then, I noticed something interesting. One of the commenters, a woman named Sandra Chen, had written, "I used to live in Mountain Vista. Patricia Hendricks tried this same thing with my property 3 years ago, claiming I needed to repaint my house because the color was non-compliant. I wasn't in the HOA either, and after I got a lawyer involved, she backed off. She does this to everyone who won't bend to her authority." I sent Sandra a private message, and she responded within an hour. We arranged to talk on the phone that afternoon. "Patricia's been HOA president for 8 years, Sandra told me. "She treats it like her personal fiefdom. The thing is, most people just comply because fighting is expensive and exhausting, but she's not always on solid legal ground. My lawyer found out that half the violations she was citing weren't actually in the HOA bylaws. She just made them up and hoped nobody would check." "Did you end up taking her to court?" "No. My lawyer sent a nasty letter threatening to sue for harassment, and she dropped it. But I heard she tried the same thing with at least 3 other people. One guy ended up selling his house just to get away from the stress. That's insane. That's Patricia. My advice: don't back down, but document everything. Keep copies of every email, every letter, every interaction. And if she keeps pushing, you might want to file a formal complaint with the county about HOA overreach." After talking with Sandra, I felt more determined than ever to fight this. I spent the rest of Friday documenting everything, printing emails, organizing the documents from the county recorder, writing down detailed notes about every interaction with Patricia and her board. Saturday brought a new development. A certified letter arrived via overnight mail. It was from Deborah Marsh, the HOA's attorney, and it was 30 pages long. The letter laid out their legal theory in excruciating detail, arguing that my property was subject to their aesthetic covenants due to the 2018 amendment, and that my refusal to comply constituted a breach of obligations that ran with the land. The letter demanded immediate removal of the icicles and payment of the accumulated fines, which were now listed as $1,500 apparently. They were charging me for Saturday too. If I didn't comply within 7 days, they threatened to file a lawsuit seeking injunctive relief, damages, and attorney's fees. I scanned the entire document and emailed it to Mark. He called me Sunday morning. "This is an intimidation tactic," he said bluntly. "The legal arguments are weak and they know it, but they're hoping you'll cave under pressure. We need to respond firmly. I'm drafting a response letter that'll explain exactly why their claims fail. But Lucas, you need to be prepared for this to get messy." "How messy?" "If they actually file a lawsuit, it'll be a matter of public record. It could drag on for months. It'll be stressful and expensive, even though I'm confident we'll win. And Patricia doesn't strike me as the type to back down easily." "I'm not removing those icicles," I said. "Not because I'm stubborn, but because if I give in now, she'll think she can push me around forever. This is about principle." "I understand. Let's fight it." Monday morning, I received another email from Patricia. This one was different. Her tone was almost conciliatory. "Mr. Kensington," it read, "I understand there's been some miscommunication regarding your property's obligations. I'd like to extend an invitation to meet with the HOA board this Wednesday evening to discuss a reasonable resolution. We pride ourselves on being a community of neighbors, and I'm sure we can find common ground. Please let me know if you can attend." I showed the email to Mark during our phone call that afternoon. "It's a trap," he said immediately. "She wants to get you in a room where she controls the environment and can pressure you. If you say anything that could be construed as acknowledging their authority, she'll use it against you. So I just ignore it. No, respond politely but firmly. Say that all communications should go through me as your legal counsel, and that you're not available for informal meetings while there's an outstanding legal dispute." I followed his advice and sent a brief, professional response. Patricia's reply came within minutes, and the conciliatory tone was gone. "Mr. Kensington, your refusal to engage in good faith negotiations will be noted in our legal filings. You're making this situation far more difficult than it needs to be." Tuesday afternoon, Marshal Thompson called me. "I wanted to give you an update," he said. "I had a meeting with Patricia Hendricks yesterday. Made it very clear that she can't use fire safety regulations as a cudgel for HOA enforcement. She wasn't happy about it, but she understands that if she misrepresents my office again, there will be consequences." "Did she back off the claims about the icicles being a fire hazard?" "She did. In fact, she sent out a correction email to her HOA board. But between you and me, I don't think she's done with you. People like her don't take being challenged well. I'm starting to realize that. Listen, you need anything from my office, documentation, testimony, whatever, you let me know. I don't like seeing government authority misused for personal vendettas." Wednesday evening, while I was making dinner, I heard vehicles again. Not just one or two this time, it sounded like a convoy. I looked outside and counted 6 cars parked along the county road near my driveway. People were getting out, maybe 20 of them in total, and they were setting up what looked like a protest. I grabbed my phone and stepped outside. The group had signs, actual printed signs. "Maintain community standards. Safety first. Stop being selfish." They were standing in a line along the road, holding their signs up toward my cabin. Patricia was there, of course, directing the crowd like a conductor. When she saw me, she called out, "Mr. Kensington, the community has a right to express their concerns about your property's impact on our neighborhood." I called the sheriff's office again. The dispatcher listened to my description of the situation. "Are they on your property?" "No, they're on the public road." "Then it's a lawful protest. As long as they're not blocking traffic or trespassing, they have a First Amendment right to be there. If they cross onto your property, call us back." The protest lasted 2 hours. As the sun set and the mountain air grew cold, the crowd gradually dispersed. But the message was clear: Patricia was mobilizing her community against me. That night, I barely slept. Every sound outside made me wonder if someone was back, if the situation was escalating further. I'd bought this cabin for peace and solitude, and now I was under siege because of frozen water on my roof. Thursday morning brought unexpected support. I woke to find that someone had posted a response on the Evergreen Community Watch Facebook group, complete with photos of Marshal Thompson's documentation and a detailed explanation of the HOA's jurisdictional overreach. The post had been shared even more widely than Patricia's original rant, and the comments were now running strongly in my favor. People were calling out the HOA for harassment, sharing their own stories of Patricia's overreach, and questioning the legality of her claims. One commenter even posted the Colorado state statutes regarding HOA authority and pointed out all the ways Patricia's position contradicted the law. I later found out that Sandra Chen had made the post, working with several other former targets of Patricia's enforcement campaigns. They'd formed an impromptu alliance to push back against what they saw as years of abuse. Friday afternoon, I received an email from Deborah Marsh, the HOA's attorney. The tone was markedly different from her previous correspondence. Mr. Kensington, after further review of the relevant property records and legal precedents, my client wishes to explore alternative resolution options. Would you be amenable to a mediated discussion regarding your property's status vis-à-vis the HOA covenants? This would be a neutral, non-binding exploration of the facts that might help both parties avoid costly litigation. I forwarded it to Mark. "They're getting nervous," he said. "The public attention probably has their board questioning Patricia's judgment. Mediation might not be a bad idea. It would give us a chance to hear their actual evidence and present ours without committing to anything. What if it's just another pressure tactic? That's why we insist on a professional mediator, not someone from the HOA. And we make it clear that participating in mediation doesn't constitute acknowledgement of their authority. I'll draft a response." The mediation was scheduled for the following Wednesday at a conference room in the Jefferson County Justice Center. The mediator was a retired judge named Harold Fleming who specialized in property disputes. Tuesday night, I couldn't shake the feeling that something was off. Patricia had been too quiet for the past few days. No emails, no surprise visits, no protests. It felt like the calm before a storm. I was right to be suspicious. Wednesday morning, 4 hours before the scheduled mediation, I received an urgent call from Mark. "Don't come to the mediation," he said without preamble. "I'm at the Justice Center now, and Deborah Marsh just showed up with 6 bankers' boxes full of what she claims is evidence. She's also got 3 additional attorneys with her. This isn't a mediation, it's an ambush." Can they do that? Technically, yes, though it's incredibly aggressive. But here's the interesting part: I got a look at some of their documents while they were setting up. Lucas, they've got forged signatures on notification letters. They're claiming the previous owner of your cabin signed acknowledgments of the HOA's expanded jurisdiction, but the signatures don't match anything in the county records. My stomach dropped. They forged documents. It looks that way. I've already pulled the mediator aside and explained what I found. He's not happy. This mediation is about to become a very different kind of meeting. Should I come down there? No, stay put. I'm going to handle this, but I need to call the county attorney's office. If they're submitting forged documents in what's essentially a legal proceeding, that's a crime. Document forgery, fraud, possibly even attempted theft by deception if they were planning to use these to get a lien on your property. The next few hours were agonizing. I tried to work, but concentration was impossible. Around 2 in the afternoon, Mark called back. The county attorney is involved now, and they're opening an investigation. Deborah Marsh is claiming she received the documents from Patricia and assumed they were legitimate. Patricia is claiming she got them from the HOA's records, which were maintained by the previous board president. Everyone's pointing fingers. What happens now? The county attorney's office is going to examine all the documents and trace their origin. If they determine there was intentional forgery with intent to defraud, someone's going to face criminal charges. In the meantime, the mediation is canceled, and Deborah Marsh has withdrawn as the HOA's legal counsel. The attorney quit immediately. She's not going to risk her law license over Patricia's vendetta. And Lucas, the board members looked shocked when the forgery allegations came out. I don't think they knew what Patricia was doing. She may have been acting on her own authority and telling the board she had everything under control. That evening, I received an email from a man named Robert Chen, Sandra's husband, who was on the Mountain Vista HOA board. The subject line was "Sincere Apologies." Mr. Kensington, the email read, "I'm writing to you personally, not as a board member. I had no knowledge of the documents Patricia presented to our attorney. The board voted to pursue your case because Patricia assured us we had clear legal authority and proper documentation. We've just learned that may not be true. An emergency board meeting has been called for tomorrow evening to discuss Patricia's conduct and her position as president. I want you to know that many of us are horrified by how this situation has developed." Thursday evening, I got a call from an unknown number. Against my better judgment, I answered. "Mr. Kensington, this is Patricia Hendricks." Her voice was clipped, lacking its usual imperious tone. "I'm calling to inform you that there's been a misunderstanding regarding certain documents. The HOA board has decided to discontinue all enforcement actions against your property pending a complete review of our jurisdictional claims." "What about the forgery allegations?" There was a long pause. "I don't know what you're talking about." "Any documents provided to our attorney came from our official records. If there are questions about authenticity, that's a matter for the county to investigate. But regardless, the HOA will not be pursuing any further action against you at this time." "At this time." "The matter is closed, Mr. Kensington. Goodbye." She hung up before I could respond. Friday morning, Mark called with another update. "The county attorney's investigation is moving forward. They've subpoenaed all of the HOA's records related to your property and the 2018 amendment. They've also interviewed several board members who are cooperating fully." "What are the chances someone actually gets charged?" "Pretty good, actually. The forgery is clear, the signatures don't match, and the purported dates on some documents don't align with other records. Someone created these documents to bolster the HOA's case. The question is who? Patricia's claiming she just maintained records she inherited. The previous board president is claiming she never saw any such documents when she was in office. Someone's lying." The weekend passed quietly. The icicles on my cabin were finally starting to melt naturally as March temperatures crept above freezing during the day. The irony wasn't lost on me. The whole crisis was resolving itself through the simple passage of time and weather. Monday brought news that the Mountain Vista HOA board had voted to remove Patricia Hendricks as president. According to Sandra Chen, who'd attended the meeting, the vote was unanimous among the board members present. Patricia had resigned from the board entirely rather than face a formal removal process. Tuesday afternoon, I received a certified letter from the new HOA president, a woman named Carol Mitchell. The letter was brief and formal, stating that all fines assessed against my property were being rescinded and that the HOA acknowledged having no jurisdiction over my cabin. There was no apology, but there was also no ambiguity. Wednesday brought the most significant development. The Jefferson County Sheriff's Office executed a search warrant on Patricia's home, seizing computers and documents. According to a brief news article in the Evergreen Mountain News, the investigation had expanded beyond document forgery to include potential embezzlement from the HOA's funds. I called Sandra Chen to see if she knew anything more. "It's been brewing for a while," she told me. "Apparently, some board members started questioning expenses after the whole situation with you blew up. They found thousands of dollars in payments to vendors that don't seem to exist." Patricia had been writing checks for legal consulting and community safety assessments to companies that have no web presence, no business licenses, nothing. The theory is that she was creating fake invoices and depositing the money into personal accounts. How much are we talking about? Current estimate is between $40,000 and $60,000 over 3 years. She was supposed to be volunteering as HOA president, but she was basically paying herself through these fake companies. The following Monday, Patricia Hendricks was arrested and charged with 12 counts including forgery, fraud, theft, and embezzlement. Her booking photo made the local news. Her distinctive haircut looked deflated, her expression a mix of anger and disbelief. Mark called me that afternoon. "I assume you saw the news. Hard to miss it. The county attorney wants to interview you as part of their case. They're building a pattern of fraudulent conduct, and your situation is a clear example. Are you willing to cooperate?" "Absolutely." I gave my statement to an investigator named Detective Sarah Morrison on Wednesday morning. She was thorough, asking detailed questions about every interaction with Patricia, every document I'd received, every claim she'd made. The interview lasted 3 hours. "Your case is interesting because it shows her willingness to create documents out of whole cloth," Detective Morrison said. "Most embezzlers try to stay under the radar. But Patricia couldn't help herself. She needed control and authority, even when it meant taking bigger risks. That's going to help us establish intent." Patricia's trial was scheduled for September, but before it could proceed, her attorney negotiated a plea deal. In exchange for pleading guilty to 8 felony counts, the prosecution agreed to recommend a sentence at the lower end of the guidelines. In October, she was sentenced to 4 years in prison, with all but 18 months suspended. She was also ordered to pay full restitution to the HOA and to the vendors she'd defrauded. Throughout all of this, I stayed in my cabin, watching the seasons change. The icicles that had started the whole crisis were long gone, replaced by spring flowers and summer greenery. My lawyer's fees ended up being around $8,000, which felt steep until Mark pointed out that we'd avoided a potentially much more expensive legal battle. The Mountain Vista HOA sent me a formal apology letter in November, signed by all current board members. They also voted to rescind the 2018 amendment claiming expanded jurisdiction, acknowledging that it had been Patricia's personal project and had never been properly vetted or approved through appropriate legal channels. I ran into Robert Chen at a coffee shop in Evergreen a few weeks before Christmas. He recognized me and came over, looking embarrassed. "Mr. Kensington, I want to apologize again in person. The board never should have let Patricia operate with such unchecked authority. We were lazy and assumed she knew what she was doing. We've implemented new oversight procedures and hired a professional management company to handle HOA operations going forward." "I appreciate that," I said. "For what it's worth, I don't hold the board responsible." You were lied to just like I was. That's generous of you. How are you doing? Still enjoying the cabin? More than ever, honestly. Although I have to admit, I keep a close eye on the icicles now. Not because of HOA rules, just because I've become weirdly conscious of them. Robert laughed. I can imagine. Listen, if you ever need anything, and I mean anything, please reach out. The HOA wants to be good neighbors, even to people who aren't members. That's what communities should actually be about. I spent that Christmas at the cabin, watching snow pile up on the pines and, yes, watching icicles form on the eaves. But this time there was no dread, no anxiety about legal letters and enforcement actions. Just the peaceful solitude I'd been seeking when I bought the place. Fire Marshal Thompson stopped by in January with a fruit basket, which was unexpected and oddly touching. Just wanted to check on you, he said. That whole situation got pretty crazy. How are you holding up? Better now that it's over. Thanks for your help, by the way. Having your documentation made a real difference. That's my job, making sure fire safety regulations aren't abused. Patricia Hendricks learned that lesson the hard way. Any new icicles forming, we walked outside and looked at the roof. A few modest formations were developing, nothing like the dramatic 20-footer from the previous year. Those are normal winter conditions, Thompson said. Nothing to worry about. And just so you know, if anyone ever tries to invoke fire safety to pressure you about property issues again, you call me directly. I don't care if it's an HOA, a neighbor, or the governor. I will, thank you. Patricia's sentence became final in February, and she reported to the Women's Correctional Facility in Cannon City in March. According to news reports, she maintained her innocence to the end, claiming she was being persecuted by vindictive board members and ungrateful homeowners who didn't appreciate her years of service. Sandra Chen organized a small gathering in April for everyone who'd been targeted by Patricia's enforcement campaigns over the years. 8 people attended, sharing stories that ranged from absurd to infuriating. One man had been threatened with fines for having a garden gnome that was supposedly visible from a common area 2 miles away. A woman had been told her Christmas lights were creating a visual disturbance, even though they were the same lights her neighbors used. The crazy thing is that we all just accepted it at first, Sandra said during the gathering. We assumed that because she was HOA president, she must have authority. It took someone actually standing up to her for the whole house of cards to collapse. I'm just glad I checked before assuming she was right, I said, and that I could afford a lawyer to fight back. Not everyone can. That was the sobering reality. Patricia had likely gotten away with years of abuse because most people couldn't afford to challenge her or were too worn down by the stress to fight. My situation had been a catalyst, but only because I'd had the resources and stubbornness to push back. The cabin became something of a local landmark over the following year. People driving through Evergreen would sometimes point it out. That's where the icicle case started. The story had taken on a life of its own in the community, morphing into a cautionary tale about HOA overreach and the importance of questioning authority. I was approached by a local journalist who wanted to write a feature story about the case for a Denver magazine. After talking with Mark to make sure there weren't any legal issues, I agreed to an interview. The resulting article, published in September, framed the story as part of a larger pattern of HOA abuse across Colorado and other states. The article quoted property law experts who explained how HOAs, despite being private organizations, could wield significant power over homeowners. It discussed the lack of oversight, the vulnerability of residents to board members who abused their positions, and the need for stronger state regulations. My case became an example of both the problem and the importance of standing up to unjust authority. Several state legislators contacted me after the article was published, asking if I'd be willing to testify in favor of HOA reform legislation. I agreed, and in November, I found myself at the state capitol in Denver, telling my story to a committee studying homeowner association regulations. The problem isn't HOAs themselves, I told the committee. The problem is when individuals within those organizations abuse their power, and there's no accountability. Patricia Hendricks operated for years without real oversight, and it took a criminal investigation to finally stop her. We need better mechanisms for homeowners to challenge unjust enforcement actions without having to hire expensive lawyers. The committee's chairwoman, a representative from Colorado Springs, nodded thoughtfully. What specific reforms would you recommend? First, a clear state standard for what HOAs can and cannot enforce beyond their formal membership. Second, a streamlined process for disputing fines and enforcement actions, maybe through a state ombudsman. Third, mandatory regular audits of HOA finances. And fourth, personal liability for board members who knowingly abuse their authority or submit fraudulent documents. The bill that eventually emerged incorporated some of these recommendations, though in watered-down form. Politics and lobbying by HOA management companies ensured that the final version wasn't as strong as reformers wanted, but it was still progress. At minimum, it created clearer guidelines about jurisdictional limits and established a dispute resolution process through the division of real estate. Through all of this, I continued living at the cabin, working my remote software job and enjoying the mountain life I'd sought from the beginning. The peace I'd found was deeper now, earned through conflict rather than simply inherited. I'd stood up for my property rights and won, and that victory resonated beyond my specific situation. Winter came around again, and with it, new icicles. These formed naturally, dramatically, beautifully. I watched them grow with a sense of appreciation rather than anxiety. They were mine, on my property, governed only by the laws of nature and the legitimate authority of actual safety regulations. One particularly cold morning in December, I stood outside with my coffee, watching the sunrise paint the icicles in shades of gold and pink. My phone buzzed with a text from Mark Davidson. Just got word that Patricia's being released on parole next week. Thought you should know. Unlikely to cause problems, but stay alert. I looked at the text for a long moment, then back at the icicles. Whatever Patricia did next, whatever path her life took after prison, it wouldn't affect my peace. I'd drawn my boundaries, defended my rights, and established clearly where my property ended and someone else's authority began. The icicles hung heavy and magnificent, frozen monuments to natural processes that required no permission, no approval, no compliance with artificial standards. They would melt when the weather warmed, and they would return when conditions were right. That cycle would continue regardless of HOA bylaws, threatened fines, or the machinations of petty tyrants. I finished my coffee, went back inside, and returned to work. The cabin was warm, the mountain was quiet, and for the first time since that white sedan had pulled up my driveway nearly 2 years ago, everything felt completely and perfectly settled. The story could have ended there, but life rarely offers such clean conclusions. Patricia Hendricks was released on parole in late December, just before Christmas. According to Sandra Chen, who'd stayed loosely connected to the Mountain Vista board, Patricia had moved in with her sister in Lakewood and was working at a retail store as part of her parole requirements. I didn't expect to hear from her again. I was wrong. In February, almost exactly 2 years after our first confrontation, I received a handwritten letter. The return address was in Lakewood, and the handwriting was precise, almost obsessively neat. "Mr. Kensington," it began, "I'm writing to you as part of my rehabilitation process. My therapist has encouraged me to acknowledge the harm I caused and to make amends where possible. I won't pretend that I've had a sudden revelation about being wrong. I still believe that communities need standards and that someone has to enforce them. But I can acknowledge that I went too far with you and with others. The methods I used were wrong, even if my intentions weren't malicious. I'm not asking for forgiveness. I know that would be presumptuous. I just wanted you to know that I've had time to reflect on my actions and their consequences. I hope you're doing well at your cabin. Patricia Hendricks." I read the letter 3 times, trying to parse whether it was genuine or another manipulation. The phrase, "even if my intentions weren't malicious," stuck out a qualifier that suggested she still didn't fully grasp the problem. But there was something in the tone, a resignation that felt real. I didn't respond. Some bridges, once burned, should stay that way. Spring arrived with its usual drama in the Colorado Rockies: sudden snowstorms, followed by warm sunshine, mud season making the roads treacherous, and finally the explosion of wildflowers across the meadows. I'd been at the cabin for nearly 2 years now, and the rhythm of the seasons had become deeply familiar. The HOA reform bill I'd testified for passed the legislature in March and was signed into law in April. It wouldn't take effect until January of the following year, but it represented progress. Other states were watching Colorado's experiment with HOA oversight, and there was talk of similar legislation spreading. I'd become something of an accidental activist, receiving emails and calls from homeowners across the state facing their own HOA battles. I couldn't help everyone, but I tried to offer advice, connect people with resources, and share the lessons I'd learned. The most common theme in these stories was the same as mine: individuals feeling powerless against organizations that wielded disproportionate authority. In May, I was invited to speak at a conference on property rights in Boulder. The audience was a mix of lawyers, activists, and frustrated homeowners. I told my story yet again, but with new perspective gained from hearing so many others. "What I learned through all of this," I said during my talk, "is that the law is often on the side of property owners, but using the law requires resources and knowledge. HOA abuse thrives in the gap between legal rights and practical enforcement. The solution isn't just better laws, though we need those. It's also about building communities of support so people don't face these battles alone." After my talk, a young woman approached me. She looked to be in her late 20s, with worried eyes and a folder clutched to her chest. "Mr. Kensington, my name is Olivia Fletcher. I'm dealing with an HOA situation right now, and I don't know what to do. They're threatening to foreclose on my condo because I disputed a fine, and I can't afford a lawyer. Can you help?" I took her information and connected her with a legal aid organization that had reached out after the reform bill passed. This was the reality for every case that became public. Dozens more played out in private, with outcomes determined by who could afford the best lawyers or who gave up first out of exhaustion. The summer passed peacefully at the cabin. I made some improvements: built a deck, upgraded the insulation, installed a better heating system for the harsh winters. The property was truly becoming mine, shaped by my choices rather than anyone else's requirements. In August, I got an unexpected visit from Fire Marshal Thompson. He pulled up in his truck, waving as he got out. "Lucas, good to see you. Got a minute?" "Always. Coffee?" "That'd be great." We sat on the new deck, drinking coffee and watching a hawk circle overhead. Finally, Thompson got to his point. "I'm retiring in November," he said. 25 years with the fire district. Figured it was time. But before I go, I wanted to thank you. Thank me. For what? For standing up to Patricia. That situation taught me something important about my job. I'd always focused on the technical aspects: fire codes, safety inspections, hazard assessments. But I'd never really thought about how my authority could be misused by others. Your case made me more vigilant about that. I've caught 2 other instances in the past year where people were citing fire safety regulations inappropriately. Might not have noticed without your situation raising my awareness. I'm glad something good came from it. More than you know. The department's implementing new protocols for how we document our findings and how we respond when someone claims fire safety concerns. We're going to make it harder for folks like Patricia to misuse our authority. That's your legacy, whether you wanted it or not. Thompson finished his coffee and stood to leave, but paused at his truck. "You planning to stay here long term? That's the idea. Why? Just glad to know these mountains have good people living in them. Take care, Lucas." Fall brought its spectacular show of color, the aspens turning gold against the evergreen backdrop. The cabin felt like home in a way my previous suburban house never had. There was something about surviving a challenge to your space that made you appreciate it more deeply. In October, I attended Patricia Hendricks' parole review hearing. I'd been notified as a victim in her case and had the right to make a statement. I wasn't sure I would until the morning of the hearing, but something compelled me to go. The hearing room in Jefferson County was small and bureaucratic. Patricia sat at a table with her parole officer, looking diminished in a way that made me uncomfortable. Prison had aged her, or maybe it was just the absence of the armor she'd worn as HOA president: the authority, the certainty, the power. When it was my turn to speak, I kept it brief. Patricia Hendricks caused me significant stress and expense. But I don't believe extending her incarceration serves any purpose. I think she understands that what she did was wrong, at least intellectually. Whether she's changed fundamentally, I can't say. But she's served her time for the crimes against me. I have no objection to her parole continuing. Patricia looked at me, and for a moment our eyes met. There was something in her expression, not quite gratitude, but perhaps acknowledgement. The hearing officer noted my statement and moved on. Patricia's parole was continued without modification. As we left the building, she approached me in the parking lot. Her sister, a tired-looking woman in her 50s, stood nearby, watching nervously. "Thank you for what you said in there," Patricia said quietly. "You didn't have to do that." "No, I didn't. But revenge isn't the same as justice. You're paying for what you did. That's enough for me. I read about the legislation, the reforms. I suppose I helped make that happen in a backward way." "You did. Sometimes it takes an extreme case to motivate change. Are you happy at your cabin?" The question caught me off guard. "Yeah, I am. Very happy." She nodded, looking past me toward the mountains visible in the distance. "I grew up in these mountains. Spent my whole life trying to make them perfect, trying to control how everything looked and felt. Funny how that turned out." "Patricia, can I ask you something?" "Sure." "Why did you care so much about those icicles? Of everything you could have focused on, why that?" She was quiet for a long moment. "Because they were there and you weren't following what I thought were the rules." I'd spent years getting people to comply with my vision of how the community should be. When you didn't, it felt like a personal rejection. Like everything I'd built was being questioned. So I kept pushing, and I couldn't see that I'd become the villain in my own story. It was the most honest she'd ever been with me. We stood there awkwardly for another moment before her sister called out that they needed to go. Patricia nodded to me and walked away. I drove back to the cabin that evening as the sun set behind the mountains, painting the sky in impossible shades of orange and purple. The confrontation I'd expected never to be fully resolved had found an unexpected conclusion, not in dramatic courtroom vindication or public apology, but in a quiet parking lot conversation that acknowledged complicated truths. The holidays came and went. Christmas at the cabin was perfect, just me, the snow, and the peace of knowing I'd earned my place here through standing up for what was right. New Year's brought reflection on the journey from that first morning when Patricia's sedan had pulled up my driveway. In January, the new HOA reform law took effect. I received a call from the Division of Real Estate asking if I'd be willing to serve on an advisory committee helping implement the new dispute resolution procedures. I agreed, figuring my experience could help shape something useful. February marked 2 full years since the crisis began. The anniversary felt significant somehow. I stood outside on a morning that mirrored that first confrontation, cold, clear, with dramatic icicles forming on the eaves. But this time there was no anxiety, no dread of white sedans and folders full of violations. My phone rang. It was Mark Davidson. "Lucas, calling with some final good news. The HOA just cut you a check for your legal fees." The restitution from Patricia's embezzlement case included compensation for people who'd incurred legal costs fighting her fraudulent enforcement actions. It's not the full amount you spent, but it's $8,500. I wasn't expecting that. Neither was I, honestly. But the county attorney's office pushed for it, and the judge agreed it was appropriate. Justice moves slowly, but sometimes it gets there. After hanging up, I deposited the check through my banking app and looked at the balance. Between the reimbursement and savings, I was in good shape. The cabin was paid off, my expenses were low, and my remote work was stable. I'd built exactly the life I wanted. Over the following months, I continued working with the Division of Real Estate on the new HOA oversight procedures. The process was slower and more bureaucratic than I'd hoped, but progress was being made. A toll-free hotline was established for homeowners to report abusive practices. Training programs were developed for HOA board members. Model bylaws were drafted to help communities avoid the pitfalls that had enabled Patricia's reign. In May, I was contacted by a documentary filmmaker working on a series about property rights in America. They wanted to feature my case as an example of successful resistance to institutional overreach. After some consideration, I agreed, stipulating that the focus should be on systemic issues rather than personal drama. The film crew came to the cabin in June, spending 3 days interviewing me, filming the property and capturing the spectacular mountain scenery. They also interviewed Mark, Fire Marshal Thompson, Sandra Chen, and even Robert Chen from the HOA board. Patricia declined to participate, which wasn't surprising. The documentary premiered at a film festival in September and was eventually picked up by a streaming service. It was strange watching myself on screen, talking about icicles and property rights and the importance of standing up to unjust authority. But the response was overwhelmingly positive, with viewers sharing their own HOA horror stories and expressing appreciation for someone fighting back. I received hundreds of messages through social media and email. Most were supportive, some sought advice, and a few were critical, accusing me of being anti-community or selfish for not just removing the icicles. I tried to respond thoughtfully, emphasizing that the issue was never really about icicles, but about property rights and accountability. One message stood out. It was from Deborah Marsh, the attorney who'd briefly represented the HOA before withdrawing over the forged documents. "Mr. Kensington, I watched the documentary and wanted to reach out. What happened with your case was a turning point in my career. I'd been doing HOA law for 15 years, usually representing associations against homeowners. After discovering those forged documents, I had to seriously reconsider what I was doing. I've since shifted my practice to primarily representing homeowners against abusive HOAs. I wanted to thank you for inadvertently redirecting my professional life towards something I find more ethically satisfying. If you ever need legal help in the future, please reach out." I responded with gratitude, glad that at least one person had emerged from the situation with positive change. The seasons turned again, and I found myself approaching 3 years at the cabin. The property had become a sanctuary not just for me, but for friends who'd visit to escape their own complicated lives. I'd installed a guest bedroom and made space for people who needed a break from the world. Sandra Chen and her husband came up several times, becoming genuine friends rather than just allies in a shared struggle. Fire Marshal Thompson, now retired, visited occasionally to check on how I was doing and share stories from his long career. Even Robert Chen stopped by once, bringing his family for a day hike on the trails around my property. Patricia Hendricks completed her parole in November, and I heard through Sandra that she'd moved to Wyoming, working as a bookkeeper for a small accounting firm. She'd apparently remarried and was trying to build a quiet life away from the community where she'd fallen so spectacularly from power. I wished her well, genuinely hoping she'd found some peace. Winter arrived with its familiar patterns. Snow accumulated on the roof, and yes, icicles formed. But now they were just ice-frozen water following the laws of physics, with no greater meaning than that. I'd knock them down when they got too heavy, not because anyone demanded it, but because it was sensible property maintenance. On a quiet evening in December, I sat on my deck wrapped in a heavy coat, watching snow fall through the trees. 3 years ago, this peace had been threatened by someone else's need for control. Now it was secure, protected not just by law but by the community I'd helped build around the principle that property rights matter and authority must be accountable. My phone lit up with a message from Mark Davidson. "Just heard from the Division of Real Estate. The new HOA dispute resolution program has processed over 200 cases in its first year. 90% were resolved without litigation. They're calling it the Kensington Protocol. Thought you'd want to know." I smiled at that, though I wasn't sure how I felt about having my name attached to bureaucratic procedures. But if it helped people avoid the stress and expense I'd gone through, I supposed I could live with the recognition. The documentary had generated enough attention that I'd been invited to speak at a national conference on property law in Washington, D.C., scheduled for the following March. It was surreal to think that frozen water on my cabin had somehow led to me becoming a voice in national conversations about housing policy and community governance. But that was the nature of our interconnected world. Small local battles could resonate far beyond their immediate context if they touched on universal principles. My fight had been about more than just icicles. It was about the right to use your property as you saw fit, within reasonable bounds. It was about challenging authority that overreached its legitimate scope. It was about holding those with power accountable for their actions. As winter deepened and the new year approached, I reflected on the journey. I'd come to these mountains seeking peace and had instead found conflict. But in working through that conflict, I discovered a more profound peace, the kind that comes from knowing you stood up for yourself and helped create positive change for others. The cabin stood solid and warm against the cold, the icicles forming and melting in their eternal cycle, and I was home. Truly, deeply, permanently home. Whatever challenges the future might bring, I knew I could face them with the same combination of principle and persistence that had carried me through the battle with Patricia and the Mountain Vista HOA. The fire crackled in the wood stove, my coffee steamed in its mug, and outside the window the mountains stood eternal under their blanket of snow. This was what I'd bought when I purchased this cabin, not just the structure and the land, but the freedom to live according to my own choices within the bounds of legitimate law and common sense. That freedom had been tested and had survived stronger than before. And somewhere out there, other people facing their own unreasonable HOA demands would hear about my case and know that standing up was possible, that victory was achievable, and that property rights still mattered in America. That knowledge was spreading, community by community, state by state, as ordinary people refused to accept unjust authority and insisted on their right to live peacefully on their own land. The icicles would form again next winter, and the winter after that, and for as many winters as I remained in this cabin. They would be beautiful, natural, and fundamentally uncontroversial, just one small piece of the mountain ecosystem that had existed long before HOAs and would continue long after. And I would be here, watching them grow and melt, content in the simple pleasure of being left alone to enjoy my property in peace.